Good morning, everybody, and welcome back to the Law and Crime Network. I'm your host, Jesse Weber. Thanks for joining us today. We actually have a very, very exciting day for you here on the network because we're covering two major trials, the continuation of two trials that we've been focusing on for the last, I think, 2 weeks or so. The first one is the Todd Kendhammer case out of Wisconsin. Now, why is this such a big deal today? I'll explain to you in a minute. But for way of background, there you go. You see him right there. That guy right there, he's on trial for the death of his wife. Now, prosecutors contend that Mr. Todd Kendhammer fatally beat his wife of 25 years and tried to conceal her death by staging a freak car accident. Kendhammer claims that really it was a car accident, that an airborne pipe fell from a flatbed truck, smashed through his windshield, and fatally struck his wife. But as I said, prosecutors in the state believe that he is covering up her murder. Now, why is today such a big day? Because it was announced yesterday that Mr. Kendhammer will be taking the stand today. That's right. A defendant taking the stand is a huge thing to watch. We saw it in multiple trials. We saw it in the Adam Matos trial. That was very interesting to watch, to say the least. So you're not going to want to miss any of that. And we have to discuss what happened yesterday with the defense's strategy. They brought on two witnesses, and I'm not sure it worked out to their benefit. We'll talk about that in a minute. But we are also covering the Xavier Dobson case out of Tennessee. This is that sad case of that 15-year-old high school football player who was fatally shot and killed when he protected his friends from gunfire. 3 men are on trial right now for his death. Christopher Jerome Bassett, Richard Gregory Williams III, and Kip Cole Jr. Those 3 men are on trial for this young boy's murder. And what we saw yesterday was some testimony about whether or not these 3 men have gang affiliations and whether or not this shooting was a result of gang affiliations. If you recall, if you're following this case, the defense attorney is really saying that this is about a girl, that this shooting was stemmed over a girl, that it had nothing to do with gang affiliations. You see those men in that rap video. The prosecution put that forward to show that they have gang ties, propensity for violence. The defense didn't want that in. That video comes back and forth throughout this case. And then you also saw testimony yesterday in the case really trying to explain why Bassett, who's, again, one of the defendants, how he got implicated in this case. Again, we're covering that case here on the network, but you can follow it live as well on lawandcrime.com. Our main focus today will be the Todd Kendhammer case because of how different this case is. You don't hear about someone trying to cover up a murder in this kind of way. I say murder, we don't know yet. This is not for me to decide, it's for the jury to decide. But it really is an interesting case, and with the defendant getting on the stand, who knows what can happen. Well, here to talk a little bit more about what we've seen and what we can expect today is criminal defense attorney and former prosecutor Bob Bianchi. Bob, good to have you back on the program.
Thanks, Jesse. Good to see you.
Now, Bob, the defendant's taking the stand. If you were the prosecutor in this case, would you just be ready to pounce?
Oh, my God, you salivate at these moments. Because, as a prosecutor, as you know, Jesse, the Fifth Amendment typically bans us or bars us from being able to get a crack at a defendant, in most instances, at least after the arrest, because they have the right to counsel. So, you really don't know what they're going to say. As a prosecutor, you kind of go in there blind, and you got to have some really seriously mad, good cross-examination skills. But there's a lot to work with here. As a prosecutor, a homicide prosecutor myself, for over half of a career, man, I've cross-examined a lot of defendants without anywhere near as much information as I could cross-examine this individual with.
We saw his interrogation tape. We saw a preview. We saw the whole 4 hours of his interrogation tape where his answers really didn't match up to her injuries, to Barbara Kendhammer's injuries. Will we see kind of a replaying of that on cross-examination, really trying to catch him in his story, that you can't explain how a pipe coming through the windshield, how she sustained half of the injuries she has? Is it kind of going to look a little bit like that interrogation tape?
Okay, well, cross-examination isn't a shootout in the Wild West. It's got to be done strategically. It's got to be done very carefully. So if I were cross-examining him in this case, I understand as an observer of human nature, we always like to say that, we're astute observers of human nature. I don't want to go too much into his world with his explanations that I don't have the ability to be able to necessarily prove they're wrong. What I train people to do when they cross-examine as prosecutors is bring out my strongest parts of my prosecution case through the witness, even if the witness answers no or I don't agree. And in this case, Jesse, it's about the forensic evidence. And that defendant was sitting in the courtroom listening to his biomechanics expert get pretty beaten up. And he also listened to all of the state's expert witnesses who did a phenomenal job at explaining the physical, objective evidence. So I would be asking questions like, well, you heard when the state's forensic pathologist came in and said that wounds to the back of the head would not be created necessarily by this particular incident. Do you agree or disagree with that? I really don't care what his answer is. As a prosecutor, I'm using it to reintroduce the themes of my case through the witnesses. And one way or the other, you may get something where he agrees with it, but even if he doesn't, the jury gets to hear again the state's theory of the case through the mouth of the defendant. And one last point that I'll bring out to you, Jesse, I was trained by what I believe to be one of the best cross-examining prosecutors I've ever seen in my career when I was a young lawyer. And he used to say this, and I believe it to be true. Jurors love nothing more than to convict a defendant out of the mouth of what he says on the witness stand. And so if he doesn't make a good appearance, or if he seems as if he's fluttering around, trying to get around that objective evidence. Remember, Jesse, that objective evidence is very powerful, both medically and with the forensic evidence. He did a great job, the state. He's going to have the defendant is going to have a very hard time when the prosecutor's asking questions in those areas that are relatively irrefutable from a scientific point of view.
Bob, one of the great reasons I love having you on here is that we get the dual perspective, former prosecutor and criminal defense attorney. So you know I'm going to ask you next. If you're his defense attorney and you put him on the stand, what do you really want to get out of him? What do you want the jurors to hear from this man? And by the way, you talk about the mouth of his own, the words coming out of the own defendant. It could backfire. We saw it in the Adam Matos case. This guy took the stand, claimed self-defense after a quadruple homicide. That didn't work out so well for him. So what would you want the defense attorney in this case to really get out of their client?
Well, we talked about this before during the opening statements, Jesse. Let me preface the answer to your question with the question is, I would never have opened up to the defendant taking the stand in the first place. Mm-hmm. You've made a commitment to the jury where at the end of the state's case, typically defense attorneys look at all the evidence that came in and they say to the client, you have this room conversation with your client, the defendant, and you say, listen, I don't think the state proved its case beyond a reasonable doubt. And what's most powerful for the defense in this case that the defense attorney was allowed to get away with was explaining that heart-wrenching kind of stuff that he was talking about the defendant, sympathizing him to the jury. And to me, that's about as good as it's going to get for him. Today, I don't believe is going to be a good day for him. That said, if I had him take the stand, I would tell him, obviously, tell the complete truth. If you don't know it, these are the typical things, Jesse. I know you know this. If you don't know an answer to a question, don't answer it. If you don't recollect, to say you don't recollect, what you shouldn't do is try to fit in an answer that you're not aware of it because you feel that you look stupid in front of the jury, because the prosecutor will drive a nail through you if you make a mistake. So try to be careful, keep your answers short, keep them honest, and whatever you do, remember, the jury's looking at you. They're observing you. You want to look sympathetic and don't overdo it. Those are about the best you could do. And then as a defense lawyer, you cross your fingers and pray to God.
Well, I think they might be doing that today, where it's going to be very interesting to watch. I do have a question for you. One of the issues in this case that keeps being brought up by different people we have on the network to talk about it is that if this was in fact a murder that he tried to conceal, isn't it a very elaborate scheme to go through this? Doesn't it seem more likely that it would be an accident? Do you think we're going to see some flavor of that while he's on the stand?
Well, let's go back to what I think personally is the most critical point as a prosecutor that I would bring out here, is that he's indicating that this pipe fell off of a flatbed truck. And this happens all the time when you investigate cases. Prosecutors go and they try to check or double check whatever it is that the defendant says. And what do they find out? Well, there's a camera. There's cameras everywhere. And there were no flatbeds that were going, up and down the highway. This would be a major area of cross-examination for me as the prosecutor to say, let's take a look at the videotape, sir. Let's see. We did this. We speeded it up. Not one flatbed went by there. Not a single one. And that's the excuse that you gave as to the reason why this happened. So I start off with that as a prosecutor as I'm moving forward. And the jury is hearing again, yeah, wow, he said this happened, yet the physical evidence is irrefutable with respect to this. So as a prosecutor, that's how you're going to go. On his end, no, I don't think this is complex. Look, I've done this for 28 years. I've handled hundreds and hundreds of investigations regarding homicide cases. I personally believe this is a secondary crime scene. I believe something had occurred prior to this, put her in the car, and he wanted to make it look like an accident or something. That it's not unusual that they go through a little bit of an elaborate thing like this, but they're not thinking when they do that there's videotapes. For example, the door was, somebody saw the door driving by that was open and the window had not been broken at that time. The glass evidence suggests there wasn't a body in the vehicle. The door being open is confirmed by the idea there's not glass in that side panel where you would expect to see it. So even though it may be an elaborate thing that he's trying to come up with, what defendants never, remember in many instances, is that there will be other physical evidence that will refute what their story is. So that's where I think that this is pretty much going to go.
Very interesting point, Bob. We are, just for our audience to let everybody know, we do expect live coverage in about 20 minutes or so in the Kendhammer case. We also do expect live coverage in the Dobson case. I want to talk to Bob Bianchi about the experts that were called to the stand yesterday by the defense. One was a glass expert, one was a biomechanics expert. I'm going to play you some of the testimony yesterday from this glass expert, and then Bob and I are going to talk about whether or not this was actually effective for the defense, or did it backfire? Let's take a look at some of the testimony from yesterday.
Here I'm showing you Exhibit 246. What is this?
So when I put my hand up into that area, these knuckles came away with more glass particles that became released. I didn't jam my fingers enough in to get the other set, but that is what we're seeing.
Next picture, please. Showing you Exhibit 247. What is this?
This is a police photo from the incident of Mr. Kendhammer's left hand.
Go to the next. Here I'm showing you Exhibit 248. Can you tell the jury what this represents, please?
This is a study that was done by a group, I believe out of Japan, where they used extremely high-speed cameras to study glass breakage in car windshield. And it was fascinating to me because it's pretty hard to get this kind of study. That kind of camera would be really pricey, something that could go to the millionth of a second. But what it's basically telling us is that when you have when you have an impact on one side of laminated glass, the crack actually starts on the opposite side. That's the main thing that this is telling you.
So and why is that?
Well, what's happening is if you have an impact on one side of the glass, then the outer surface of glass is being the most stretched. And it's being put in what we call tension, which means pulling it apart. So it's the first thing to really open up and to start to form those cracks.
And how long after let's say if the impact came from the inside, how long after the outer pane of glass broke is it before the inner pane of glass breaks?
Only about 760 millionths of a second. So you could think of it as a thousandth of a second. And those are the types of time intervals that we really have to think about when we talk about glass, because everything happens so quickly. So the outer layer, in this case, when Mr. Kendhammer's hand hit the glass, the outer layer broke first to the tune of, let's say, a thousandth of an inch faster, and then the inner layer started to go through that same process. And then the other thing you need to know is that when the cracks propagated out, when they got out to a certain extent, then the circular patterns would form roughly at the same time that the radial patterns were to reach it.
I'm showing you Exhibit 249. What does this depict?
So this is fracture number 1, where Mr. Kendhammer's hand punched in from beneath this. This is the exterior face of the glass, and the line along which his upper knuckles would contact would be along this line, and that fold that became the fracture origin is down here. And these radial cracks you can see are rising up and over the ridge, and they pretty much shoot off in all directions.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. So there you go. That was some testimony yesterday in the Todd Kendhammer case out of Wisconsin. A glass expert. I know. So that we actually have glass experts. That's a thing. Well, a glass expert, as you just saw, was called to the stand by the defense team, and what he testified to was that there were 3 impacts in that windshield. The first was from Todd Kendhammer's hand hitting the windshield, and as he said, he tried to, he thought it was a way that, remember, Todd Kendhammer thought that it was maybe a bird, eventually he said it was a pipe that came towards the windshield, and he stuck out his hand towards the windshield to try and block it. That was the first impact. The second was from the pipe actually going through the windshield. This witness said that the windshield had a circular impact part from it, indicating a pipe went through. And the third impact was the prying action when the pipe was removed. Now that seems to be pretty strong evidence that supports the defense's case that this was a pipe that hit the windshield. However, under cross-examination and under further analysis, it still didn't alleviate the question of could this have been staged. So let's talk a little bit about it with our guest today, Bob Bianchi, former prosecutor, criminal defense attorney. Bob, let's just talk about the glass expert right now. On one hand, his testimony seemed to help the defense, but did it really? What do you think?
I think that it sounded great on direct examination, but on cross-examination, the prosecutor did a great job of explaining it could have been multiple different reasons, including the fact that it was orchestrated. And he didn't necessarily disagree with that opinion. So it was surprising to me that the defense put him on because it did not conclusively establish that the prosecution's theory of the case was not accurate. And this is, look, expert witnesses are a specialty item in criminal trial work. As your audience probably knows or should know, is an expert witness is different than a fact witness for one very important reason. Because of their experience and their training, once they qualify as an expert in their field, they're allowed to give their opinion. All other witnesses can only testify about facts. What did they see? What did they taste, feel, touch? Those things. They're not allowed to opine about a particular thing. Experts are. So you want your expert to be really good. So here's your trial practice point for your audience to know. You look at an expert witness when you're cross-examining them as a lion in a cage. You don't want to step into the cage. You want to make sure that the cage is locked when you're cross-examining them. You want to take a big stick and you want to kind of poke them a little bit, but you never want to get into the cage with the lion because the lion will eat you up. Experts have more knowledge than you do, so you don't want to argue science with them, typically speaking. So you kind of go there and you lock them in on cross-examination. You poke them a little bit, you back up, you see how they respond to it. And I have seen great lawyers eviscerate expert witnesses based on common sense. And that's exactly what this prosecutor did. He didn't jump so much into the science, but he went into the common sense, and he brought his theory of the case, the prosecutor's theory of the case, into that expert's cross-examination, and the expert didn't do a very good job at confronting it. So I thought that it sounded great on direct examination, but the prosecutor did a phenomenal job on cross-examination.
Yeah, you make a great point, Bob, because at the end of the day, we don't know the timing of those impacts, and this could have been, again, a stage. It could have staged this accident. You know, if he still could have hit his hand against the glass, he still could have had that pipe go through. And obviously there was back and forth about what force and exertion was and all that. But at the end of the day, I think you make a great point that maybe it wasn't as effective as they would have liked. And speaking of effective witnesses, we saw the testimony of Dr. Barry Bates, who again testified about biomechanics. Bob, this witness brought out by the defense, not so good for them, right? Didn't he contradict his earlier testimony?
Yeah, and so here's the other thing. When you are preparing your own expert, I do this all the time. I give them all the data in the case, everything. I tell them they need to review everything, even if they're not going to use it as part of their opinion. It's brutal when they're being cross-examined, when the guy's saying, well, I really didn't look into that. No, I didn't take that piece of evidence into consideration. And no, I didn't review this because it wasn't relevant to my opinion. It just looks really poor in front of the jury that this person doesn't have all of the facts necessary to come to the expert conclusion that they did. So the prosecutor was very effective in bringing that out. And to me, it was a sophomore mistake by the defense. And this defense lawyer is good, so I don't want to be overly critical here. But, you know, when you're at the dance in the courtroom in front of the jury, you know there are certain things that a good cross-examiner is going to do, and that's one of them. So when this biomechanics expert's saying, I only really looked at 3 photos, I believe it was. I didn't really look at that, and I didn't need to look at this. It just came off poorly from the credibility point of view of that expert. Not to mention that substantively, when you get into the substantive testimony, the prosecutor did a very good job at explaining a multitude of other things that could have also been true. Again, bringing out the themes of the prosecution's case through the expert witness. That's what the prosecutor did on cross. I thought he did a very good job with that. Again, a second witness that would have been very powerful, but to me kind of fell apart on cross-examination.
Yeah, right. He said he didn't even really investigate the neck injuries to Barb, and he was talking about the various injuries to Barbara Kendhammer, and he said that it was possible that while she was sitting in the passenger seat, she ducked down and to her right as the pipe came through the windshield. But then what he basically concluded was during cross, he admitted 2 things that contradicted his earlier testimony about these injuries. The major point being that he didn't even believe that a pipe fell off the truck. Again, this is a defense expert. And Bates told jurors that in his report, it was possible that she was strangled. He said it would be difficult, but he said it was possible. When you concede those facts to the prosecution, not a great day for the defense.
No, the witnesses at a minimum, these witnesses have at a minimum been neutralized by the prosecutor, or, in my estimation, have actually improved the prosecution's case.
Yeah. Bob, I want to talk a little bit about the Xavier and Dobson case as we wait for a live feed in both of those cases. Again, this is the case of this young 15-year-old boy who was a high school football player, and he was shot and killed when he was shielding his friends from gunfire, and 3 men are on trial for this. Bob, real quickly, I want to talk to you about this case, the real big issue about this gang affiliation. We talk about this constantly in the case because there was a rap video that apparently these 3 men were in. The prosecution wanted it in to show their gang affiliation. The defense did not want that in, even at one point saying that this was going to chill free speech. People wouldn't make these videos out of fear. Again, a lot of things to dissect about this gang affiliation. What do you make of this?
Okay, so we're about to tell your audience the most complicated evidence rule in trial law. It's usually called evidence 404.
All right, keep it simple for our audience, Bob.
Yeah, I'm going to bring it down to like real basics. 404B. 404B evidence basically says, like, look at a trial like a football field. There are certain rules, certain goal lines that you have to go to. You can't violate the rules to bring the ball forward. You have to comply with those rules. That's what the evidence rules are. And the evidence rules essentially are built so that it's a fair playing field and that the trial is about the facts of a case and not all sorts of bad character evidence. And that's what evidence rule 404 deals with. It basically is what they call a rule of exclusion, which means you cannot introduce evidence of other wrongs or bad acts or bad conduct that don't have to deal directly with the trial, and the judge has to weigh whether or not a particular piece of evidence that way is what they say its probative value, that is the value of it to the prosecutor, is outweighed by prejudicial effect. Here's the bottom line to it. They don't want to make it a character assassination trial, and that rule is to prevent it. As a prosecutor, I think it's a sign of desperation in the prosecution's case that they tried to introduce the gang affiliation. That is what we call other bad acts or bad character. And again, it's what the court doesn't want you to do. There are certain exceptions to that rule. It may be motive, opportunity, intent, preparation, or plan. But there is nothing here about that rap video other than somebody identified one of the actors in that limited that video, that rap video, which again, people do videos for all sorts of reasons. They believe in or not, they believe in some form. I would be very careful about this because an appellate court down the road could sit there and say, you broke that rule, you went over the line, you went foul here, and it could cause a reversal of the trial. As a prosecutor, when I've had great 404 evidence, that is bad character evidence, to show this person's really not a good human being, I'm very careful to introduce it so that I think about the appellate division and I say, will they understand I have very powerful reason to introduce bad character evidence. I had a homicide case with a priest who was murdered, and there was a warrant that the person who worked at the school had against them for 20 years for sexual abuse of a child. When the priest found out about it, he fired him, which we believed was the motive for the firing. That is, the priest found out about this 20-year-old really bad warrant. So we were able to introduce that 404 evidence, that bad character evidence, but it was going specifically to something that was important to the case, that is the motive for the killing. And we also had other really bad stuff about the guy's background, but we chose not to use it. And in fact, when it went all the way to the Supreme Court of New Jersey, they said, well, we're not going to overturn this conviction because the prosecutor was very careful to only introduce the bad character evidence because it's specifically related to motive in the trial, and he purposely did not introduce all sorts of other bad character evidence. So we believe the prosecutor was balanced and using their discretion. To me, throwing in here gang stuff, which he's not being charged with being a gang member, or about videos that misconstrued, opens the door for a reversal of a conviction at trial. I think it was a big mistake in my mind. The prosecutor has to protect the case for appeal.
Yeah, we'll have to see how that one plays out. And you make a good point about motive, because they're trying to pin down a motive in the Dobson case, but we're kind of left without a motive in the Kendhammer case, which is, again, what we're focusing on, and we will probably have live coverage in about 5 or 10 minutes. And Bob, Xavier and Dobson case, which you can watch at lawandcrime.com when that one starts as well. But again, with the Kendhammer case, we're trying to find a motive. So let's actually play some testimony again from yesterday from the defense's witness, again, this glass expert. Again, their attempt to try to show that this was an accident. But I do want to talk to Bob after this about a potential motive, and then we'll go to a live courtroom feed once we have it. So in the meantime, here's from some testimony from yesterday.
Now, you asked some questions about